Welcome back me channel. Today we discuss about child custody lawyer and best interest of the child, know your rights, family lawyers. Both parents have an equal say in their child's upbringing and if the father has taken on their share of responsibility as an equal, then they will have equal say when custody is decided. However, the court has to weigh up which parent has taken responsibility as they should have and which is the primary carer. What does a family law solicitor do? Most local family law solicitors can assist with divorce settlements, cohabitation agreements, childcare proceedings, and a whole host of other legal issues around divorce and separation. What is the most common child custody arrangement UK? Shared parenting is increasingly common in the UK. It gives each parent at least 40% of their child's time. One shared parenting option. The 2 to 5-5 schedule has your child spend 2 days with each parent, followed by 5 days with each parent. This creates a 50-50th division of parenting time. What is the child's best interest in custody cases? Put simply, the best interests of the child are whatever is best for that individual child. Vunkirk expressly recognizes the role of parents and carers, including extended family, guardians, and others with legal responsibility in protecting and promoting the best interests of the child. How do you prove the best interests of the child? 1. The child's age. If a child is very young, under 18 months of age, then they may be more reliant on their mother, especially if she is breastfeeding the child. -2. Consistency of care. 3. Safety and well-being. -4. Evidence of parental ability. Who has parenting time for best interest of the child? *. Prepare a parenting plan. * Keep track of your parenting time. * Maintain a journal to show you meet parenting duties. * Keep a log of child-related expenses. * Get reliable child care. Ask others to testify on your behalf. * Show that you're willing to work with the other parent. What is the best interest of the child case law UK? According to Article 3.1 of the Convention, in all actions concerning children, whether undertaken by public or private social welfare institutions, courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration. What is a special interest of a child? Personal interests. These are a child's favorite things, such as cars, water play, or music. Situational interests. These interests emerge when something about an activity, material, or person attracts a child's attention or invites him to become involved. What is the best interest standard? The best interest standard has been defined as a child-centered and family-oriented understanding of prioritizing the child's well-being as defined by family and supported by the medical team. What type of custody is most common? Joint custody is the most common type of child custody arrangement, but there are different types of joint custody and, in some cases, sole custody may be the best solution. Here's what to consider when negotiating child custody. What is the most common child custody arrangement UK? Shared parenting is increasingly common in the UK. It gives each parent at least 40% of their child's time. 1 shared parenting option. The 2 to 5-5 schedule has your child spend 2 days with each parent, followed by 5 days with each parent. This creates a 50-50th division of parenting time. What type of custody is best for a child? Joint legal custody. This is the type of custody the courts prefer to rule in, as long as it's in the best interest of the children. The benefit of joint legal custody is that children get to grow up with equal influence from both parents. What is considered the best interests of the child? The best interests of a child will depend on the circumstances, For each different case, there may be many factors to consider when deciding what is in the best interests of the child. To do something in a child's best interests usually refers to making a decision according to what will most benefit the child's general well-being. The guiding principle of the Children Act 1989 is that the child's best interests are of paramount importance in all decisions made. Section 1 of the Children Act 1989 lays out a welfare checklist, which can be used to help to determine what is in the child's best interests. The 7 points in the checklist are as follows. 1. The ascertainable wishes and feelings of the child concerned, considered in the light of his age and understanding. 2. His physical, emotional, and educational needs. 3. The likely effect on him of any change in his circumstances, his age, sex, background, and any characteristics of his that the court considers relevant, any harm which he has suffered or is at risk of suffering, how capable each of his parents and any other person in relation to whom the court considers the question to be relevant is of meeting his needs. The range of powers available to the court under this act in the proceedings in question. How do you prove the best interest of the child? When submitting evidence to prove that a decision is in a child's best interests, it can be useful to consult the welfare checklist above and find evidence that proves that the decision supports as many of the points as possible. The child's age. If a child is very young, under 18 months of age, then they may be more reliant on their mother, especially if she is breastfeeding the child. This would have a significant impact on the court's decision. For older children, the court will determine their level of understanding and then take into consideration their wishes and feelings if they decide they are mature enough to form their own opinions on the matter. Consistency of care. The court will usually try to avoid causing too much disruption to a child's life and aim to keep a child's care and routine as consistent as possible. The benefits of consistency will of course be balanced against other factors to ensure the child's best interests are still being looked after. Safety and well-being. The child's safety and well-being are always considered to be of paramount importance in all decisions made. A court will not make any decisions that compromise a child's safety. Evidence of parental ability. The court will look for evidence of a person's ability to meet the child's physical and emotional needs. The court will need proof that the parent can meet the child's most basic needs, including food, shelter, education, and medical care. They will also take into consideration the parent's physical and mental health and well-being and their ability to provide the child with emotional support and parental guidance. The best way to prove that you have a child's best interests at heart is to give evidence that you have been actively engaged in their life and upbringing. What exactly is an unfit parent in the eyes of the law? The legal definition of an unfit parent is when the parent through their conduct fails to provide proper guidance, care, or support. Also, if there is abuse, neglect, or substance abuse issues, that parent will be deemed unfit. Do Cafcass favor mothers? Cafcass advice for mothers. It's a common misconception that Cafcass can offer advice. However, they aren't necessarily neutral family court advisors. As such, they cannot offer legal or other advice to either parent. What not to say to Cafcass? Don't exaggerate. Don't get so caught up in your ex-partner's allegations that you forget to put forward your child-focused arrangements. This is a very common failure. Don't lose your cool, become angry, or appear unreasonably emotional. Don't argue or be sarcastic with the Cafcass officer. What do Cafcass look at? Cafcass represents children in family court cases in England. We independently advise the family courts about what is safe for children and in their best interests. Do Cafcass speak to both parents? Cafcass will also usually speak to each parent, usually be telephoned to give them an opportunity to explain any safeguarding or welfare concerns they have. What powers do Cafcass have? Cafcass' role in care proceedings. Appoint a solicitor to represent your child. Advise the court at the first court hearing on the work that needs to be done before it can make a decision about your child's future. Thanks for watching. Subscribe for more informative video.